This is Joel Crim with the law offices of Shipman Crim. And today's blog entry is about the new effect of the Interlock device law, essentially on DUI first offenders. And specifically, the question I want to address: people having read articles in local newspapers are curious about the fact of what happens if someone with no previous violations for either the implied consent statute or DUI, if they are pulled over and refuse to submit to a blood or breath test, if the court will impose interlock on their vehicle. One of the papers in Nashville wrote, also under the new law, someone convicted of DUI with a minor in the vehicle and those drivers who refuse to take a breath test or blood test at the time of the DUI arrest are required to have interlock installed in their vehicles. And I've sensed a little confusion with people that have read some of these articles. They seem to believe that if you refuse to blow or to give a breath sample or blood sample, then the court will mandate that an interlock device gets put in your vehicle. And based on my reading of the statute, that is incorrect. What the statute essentially provides for is, if someone is convicted of a DUI first, the law permits them to get a restricted driver's license. They can do that essentially if they've not been convicted of vehicular assault, vehicular homicide by intoxication, aggravated vehicular homicide, or they don't have a prior violation for DUI, or the old adult driving while impaired, which hasn't been on the book since 2003. Essentially, and this again is for DUI first only, the only time the interlock device comes into play is when someone is convicted of driving under the influence. And specifically, so you have to be convicted of driving under the influence and also be in violation of the implied consent statute. That essentially means you don't give a blood or breath sample when requested to by the police. Furthermore, it's not mandatory that the judge install the interlock into your vehicle at all. This is only when you request to get a restricted driver's license that will permit you to drive to work or to school or to church or to any meetings about treatment or to get your interlock fixed. And then that only applies if, according to the statute, if you're convicted of a DUI, number one. Then, if you're also found to be in violation of the implied consent statute, and you've either had an implied consent violation within the past 5 years, you've been convicted of underage driving while impaired, then open container law, or reckless driving if the charged offense was in fact driving under the influence. So essentially, the answer to questions that I've received before, what if I've been charged with driving under the influence and I refused to give a breath sample or a blood sample? The answer is, if you're not convicted of driving under the influence and you're not, then you will not be required to get an interlock device in order to get a restricted driver's license. Again, it only applies if you are in fact convicted of driving under the influence. Now keep in mind, this is only for an analysis under first offense driving under the influence. Now understand that the driving under the influence statute in Tennessee is very complex, because there have been several instances, just like we've just experienced, that the law is tinkered with, and legislators try to make it in order to save lives in Tennessee. But again, I think they've done a decent job at trying to focus solely on people that drive much over the limit, as well as those who pose more of a danger than your average citizen that just simply has too much to drink. The way that they have implemented that is, furthermore, if you are convicted of driving under the influence and you seek to get a restricted driver's license, you will have to get the interlock device if it's determined that your blood or breath alcohol concentration is a 0.15. If someone in the vehicle is under the age of 18, and if you've been involved in a vehicle accident and it's determined that your intoxication was the proximate result of that vehicle accident.
No.